Good morning, everyone, and welcome to the Kuits Corporate Team's webinar on the Economic Crime and Corporate Transparency Act 2023, which we affectionately refer to as ECCTA. I'm Kirsty Pennell, Head of the Corporate Team, and my colleagues who will be presenting this webinar are Helen Mather, who will take us through a summary of what ECCTA is and what the reforms include, with an overview of what is already in force. Olivia McConvey, who will outline who the new identification and verification processes will apply to, how it is anticipated these will be undertaken, and the consequences of not complying, bearing in mind that the devil will be in the detail, which still is to be legislated for. Cameron Shaw will then outline the new Companies Act, or Companies House powers, before going through some scams, which you should all be aware of and how to avoid falling foul of them. Helen will finish off with what all companies should be doing and how we can help before we move on to any questions. Taking a step back before we start, it's worth bearing in mind that ECCTA is mainly aimed at preventing the abuse of UK corporate structures and tackling economic crime. Many of its provisions make sense in light of that. Compared to the rest of the world, forming a company in the UK is currently very easy, but soon the identity of those involved with legal entities will need to have their identity verified, which is intended to help prevent abuse of corporate entities by organised criminals, fraudsters and terrorists, something we're all keen on doing, I'm sure. All of this makes sense, but will involve more red tape, something which we are here to help you with, but it's also something to bear in mind that we're all used to dealing with banks and other professionals at the moment. So, time to get started with our webinar, and I'll now hand over to Helen.
Good morning, everyone. So, as Kirsty's outlined, we're here to talk today about the snappily titled Economic Crime and Corporate Transparency Act 2023, or ECCTA for short. It's a new piece of legislation that forms part of the government's wider strategy to reduce economic crime in the UK. It includes a wide range of reforms that will affect all companies, as well as also affecting LLPs and limited partnerships in various ways. I'll focus on companies in this webinar. The name of the act is a bit off-putting and I think can mislead companies and business owners to think it doesn't apply to them because they aren't involved in economic crime. However, ECCTA makes reforms that apply to all companies. ECCTA's coming into force in stages. Parts are already in place and the rest will be implemented over time. The overall timetable for implementation and some of the detail of the requirements and obligations are unclear, as further legislation is required to clarify them. It was originally expected many of the changes will be implemented in 2024, but there has recently been confirmation that some of the changes will be delayed. For example, ID verification is now expected to be implemented during the first half of 2025. We don't have time today to go through or even to mention all of the changes that ECCTA is bringing in. But to give you an idea of some of the things it covers, the reforms include reforming the role of Companies House by bringing in identity verification requirements for directors of companies, and persons with significant control of a company, amongst others. ECCTA has already introduced new powers that Companies House has, including to require additional information or remove or reject information that has been filed and to impose fines and criminal sanctions. Companies House can also analyse and disclose information provided to it to any person or public authority for the purposes of crime prevention or detection. Companies House are now expected to be actively involved in preventing economic crime. Cameron is going to discuss these powers in more detail shortly. ECCTA will also be changing how documents can be filed at Companies House and who can file them. Other changes outside of the changes to Companies House, and to demonstrate kind of how sort of broad the legislation actually is, include changes to the law on corporate criminal liability for economic crime, new powers to seize and destroy crypto assets which are involved in crime, a new corporate failure to prevent fraud offence, which won't come into force until the government publishes statutory guidance relating to the offence. However, we do know so far that it can only be committed by large organisations, and that it will be a defence for a company to prove that it had appropriate prevention procedures. It's expected that it will be similar to the Bribery Act offence in a lot of ways, but it remains to be seen. ECCTA also introduces changes to the Register of Overseas Entities regime, which is a register that records overseas entities that own land in the UK and the beneficial owners of those entities. So the reforms that are already in force include, since December 2023, the changes to the law on corporate criminal liability for economic crimes. And that essentially makes the actions of senior managers such that they can result in the company being criminally liable, whereas before it was generally just directors that could do that. Since the 4th of March 2024, some of the changes relating to the Register of Overseas Entities and various of the reforms relating to Companies House's new powers, which we'll talk about a bit more shortly, and some of the new corporate filing requirements came into force. For example, if you've filed an annual confirmation statement or incorporated a company recently, you may have noticed some of these changes, such that a company's registered office must now be an appropriate address, and companies must maintain a registered appropriate email address for communication with Companies House. And it's also a requirement for all shareholders forming a company to confirm on incorporation that they are forming the company for a lawful purpose, and on their confirmation statement that the company's future activities will be lawful, although I'm not really sure who would not tick that box. And then since the 2nd of May, increases in Companies House fees have taken effect, in large part, as I'm sure you can appreciate, to fund all of these new functions. I'll now pass over to Olivia, who's going to talk about ID verification.
Thanks, Helen, and good morning, everyone. So as Helen's touched on, today I'm going to talk about what I feel is the biggest and most onerous reform to be introduced by ECCTA, and that's a requirement for all new and existing directors of a company to identify verify their identity at Companies House unless they're exempt, for example, for national security reasons. So identity verification will also apply to persons with significant control in relevant legal entities and anyone else who is submitting filings on behalf of a company. Where a UK company has a corporate director, all directors of the corporate director, who must be human beings, must also have their IDs verified. Where a PSC is a relevant legal entity, for example, a UK company, a relevant officer or director of that RLE, who is a natural person, must also be ID verified. So when ID verification comes in, there's going to be two ways to verify an individual's identity. And they are the direct verification route via Companies House online, or what is known as the indirect route, which will be a verification statement delivered to Companies House in respect of that individual, and that will be made by an authorised corporate service provider, or an ACSP as it's known as for short. So an ACSP is a third-party agent who will be registered at Companies House, who are authorised to verify identity because they themselves follow anti-money laundering regulations. So, for example, a law firm like Kuits or an accountant. And then that ACSP will be able to file documents at Companies House on behalf of others, so other companies and directors. So this hasn't come into force yet, and the final guidance hasn't been published yet. But the government's 2022 white paper suggests that the direct verification route via Companies House will be digital, utilising facial recognition technology alongside an individual's photo ID. So similar to the process that we use at the minute when we reapply for passports and driving licenses, for example. The aim is that using the direct route online, should only take a matter of minutes if you have the required photo ID to be able to use that service. It is important to note, though, that the photo and the ID document won't appear on the public register. So verified individuals will have a single user account, but then multiple roles across multiple companies will be easily linked, and searchers, if they search an individual, so a director, they'll be able to see their different roles across a number of companies and other entities, and that information will all be on one place in the register. So the idea is that there'll be more reliable information about PSCs and directors and group companies, which is then available on the public record for searchers to see. A verified account is going to be mandatory to incorporate a company or to file for an existing company with Companies House. And all verified individuals will be given a unique identifier number, which will allow them to file at Companies House. And what we do know is that when you are given that number, you should keep it confidential. So the hope is that ID verification will be a one-off exercise, although it may be required to re-verify if any of the information or evidence that has been relied on by Companies House or that an individual is given to an ACSP for identity verification is false, misleading, or deceptive in any material way. There will be consequences to not complying with identity verification. And a director should not take any actions on behalf of the company until their ID is verified. It will be a criminal offence to act as a director without having your identity verified, and continuing to act as a director without being verified will amount to an offence committed by that officer, the company, and every officer in the company who was aware that the unverified director was continuing to act. And this is punishable by a fine, a level 5 fine, which is unlimited. Although, importantly, we should note that any actions undertaken by a director who is unverified, so if they enter into a contract or a lease, for example, when they're not verified, that action won't be invalidated. But if a director persistently acts without having been verified, they may face disqualification as a director. And worst case scenario, that unverified director could end up in prison. So it's slightly different with PSCs and RLEs as we know at the minute. And what we do know is that if their ID isn't verified, this will show on Companies House, and the word unverified will appear on the register next to their names. And this could be a cause for concern, for example, for lenders or suppliers who search the register and then find out that the PSC of a company is unverified. It's going to make them question why they haven't taken the steps to verify their ID. So this identity verification requirement hasn't come into force yet. And that's because the government needs to produce the software, the secondary legislation, and the guidance before it comes into force. Aside from knowing that the direct route will require photo ID, the rest of the details haven't been published yet. The most recent update in terms of timings was that this will come into force in early 2025, but this timeline has already been extended as we were expecting it to come in late 2024. And the recent change in government may cause a further delay to implementation because there's always that settling in period and change of priority for a new government. There is expected to be lead-in time before implementation because of this parliamentary timetable and the passing of secondary legislation that's required. And we're hoping that we can expect a full implementation timetable to be published shortly. There will be a transition period when this does come into force for all existing directors and PSCs to verify their identity. And it's going to give, we don't know how long that will be, but enough time for existing directors and PSCs and ACSPs to comply with those new requirements for identity verification. The government's hope is that with this new identity verification requirement, But it's going to make it harder for people to register fictitious directors and beneficial owners of companies, and that ultimately that's going to cut down on economic crimes and crimes in general, because there's going to be visibility and transparency of company ownership, which is available on the public register. And also Companies House are going to be able to see who it is who is actually being appointed as directors. There's a few things that we can do now and you can do now. For example, briefing the board of directors about this new reform and making sure people are aware that they will be required to verify their identity. So they're going to need a photo ID available, and to maybe start digging that out now. So that's all from me this morning. And now I'm going to pass it over to my colleague Cameron Shaw. And he's going to tell you about Companies House new powers and some scams that you should be aware of. So thank you.
Thanks, Liv. And morning all. Companies House new powers. As mentioned by Helen, ECCTA has introduced a number of new sections into the Companies Act 2006, which set out, amongst other things, that Companies House now has enhanced objectives which require it to promote and maintain the integrity of its registers that it keeps. To support these objectives, ECCTA has provided Companies House with greater powers. And to give you an idea of the new powers, Companies House can now reject a new filing if it appears inconsistent with information held by it already, require additional information to satisfy a query that it has about information delivered to it, require inconsistencies to be resolved, and to remove non-compliant material from its registers. So taking, for instance, the power of Companies House to require additional information, it has been suggested that such power will be exercised with discretion using a risk-based approach, which prioritizes the biggest risks to the integrity of the register and the quality of information that it holds. So generally, it is the expectation of Companies House that it will also crack down on erroneous filings, targeting companies with poor filing histories and holding both existing and new directors accountable. So to give you a flavour of some more examples of the new powers given to Companies House, which are currently now in place. Every UK company is now required to provide a registered email address to Companies House. Companies House will use this email address to communicate with the company, and it won't be available to view by the public. All UK companies are now required to ensure that the registered office address is an appropriate location. This means a location in the ordinary course of events that documents can be expected to come to the attention of someone acting for the company, and where delivery can be recorded by obtaining an acknowledgement of delivery. This means in some instances that some companies may need to move their registered office address if it is currently using a PO box as its registered office. So in addition, as part of the annual confirmation statement process, a UK company will need to confirm that the intended future activities of the company will be lawful. This applies to confirmation statements with a statement date of or from the 5th of March 2024 onwards. And it is also worth noting a similar statement is also required as part of the application process when incorporating a new company. There are also restrictions on company names. A UK company cannot be registered with a name which contains a computer code or which would be likely to give the false impression that the company is connected with a foreign government or international organization, or, well, which makes sense, is intended to facilitate offences involving dishonesty or deception. So alongside the new powers that have been provided to Companies House, It now has the power, as of the 2nd of May 2024, to impose civil penalties, including fines. For most offences introduced by ECCTA, these fines can be up to £10,000, and it is understood that Companies House will publish guidance on how it will exercise its new powers under the regulations before it starts issuing financial penalties. So moving on to scams to be aware of. And so scammers have been targeting business owners impersonating Companies House for some time. And following the recent changes that have been announced by the introduction of ECCTA, I suspect that these scammers will no doubt continue and become more prevalent. To give an example, recently a scam letter came across our desks, and needless to say, we knew it was a scam straight away for a few reasons, which you'll see highlighted. There's a spelling mistake on the first page. The letter refers to an 8-digit payment code and asks for payment via a short URL or QR code, which Companies House will not do. It also refers to paying HMRC, which is a separate entity to Companies House. So given that we deal with Companies House on a daily basis, it was easy for us to spot the letter was a scam. But for a busy person trying to run a business, it may not be so simple, which is why it's crucial to be aware of these scams. Some other examples of scam attempts made against companies include companies receiving scam telephone calls asking companies for either payment of a late filing penalty or its authentication code. Companies have also received scam emails claiming to be from either Companies House or HMRC, asking either to verify their identity or use an e-sign platform to review documents affecting the business. And these are a couple of examples, one relating to the Economic Crime and Corporate Transparency Bill, which is fairly relevant. So Companies House has provided some guidance online to avoid falling foul of scam attempts like these, which includes, I mean, most importantly, it will not contact you for an immediate payment of a late filing penalty or request a nominal fee to place a hold on any recovery action. It will never ask for a company's authentication code over the phone. Companies House also asks that each person just double checks email addresses of senders, and if you receive any unusual emails, Companies House have set up a forwarding address, which is on the slide now. Companies House also do ask that you delete any emails from your mailbox and do not disclose any information or click on any links. And also, as I say, do not view or open any attachments contained in any unusual emails, which again, Companies House have provided guidance on. The general advice as to how to avoid these scams is to essentially keep up to date on the latest scams, which you can see on the link that we've provided in the third bullet point. And always just double check email addresses, and if you're unsure about any emails, do forward them on to Companies House. But now back over to Helen to talk about what you should be doing.
Thanks, Cameron. So It's important that companies are ready for each stage of implementation of ECCTA because non-compliance is in most cases a criminal offence by the company and its officers. As we've already touched on, the penalties for non-compliance can be severe. For example, directors can be disqualified if they have had 3 or more breaches of company's legislation, for example, such as non-compliance with filing obligations at Companies House. And many of the offences carry unlimited fines, and some can actually result in imprisonment. There's a lot more to ECCTA than we've touched on today, and given the wide range of reforms and that many of the changes are not yet fully understood, it's understandably difficult for business owners and managers to keep on top of the changes and their obligations. So companies should firstly make sure that the directors and relevant managers are aware of ECCTA and that from there that they are kept up to date. Some things that we could assist with from a practical point of view at the moment are providing you with a briefing note for your board of directors that could pull everything together. We could review your historic Companies House filings to ensure they're compliant. And going forwards, we could help you to draft policies and procedures to minimise your exposure, such as relating to the failure to prevent fraud offence. If you'd like any more information or have any questions about any of the matters we've covered or anything else to do with ECCTA, then of course, please let us know and we'd be more than happy to help. I'll now pass you back over to Kirsty.
Thank you, team. And sorry, a bit of a technical hitch there with my camera. That does conclude our summary of the current main provisions and implications of ECCTA, which I hope you've now got a better feel for and understanding. And obviously, as Helen said, we're here to help you if you have any further questions. But I have got, I think, a couple of actual specific questions. And obviously, if anybody else has some, just put them through on the chat. First question. Is what is a large organisation that can commit the failure to prevent offence? I think, Helen, that's probably one for you. I'm sure people want to know whether or not they fall within that category.
Thanks, Kirsty. Yes, so essentially that is an organisation that satisfies 2 or more of the following criteria. So either having more than 250 employees, more than 36 million of turnover, or more than 18 million in assets. So if you tick in 2 of those boxes, then you'll be a large organisation and the failure to prevent fraud offence will be relevant to you. So there's going to be some risk assessments to be carried out and probably policies, procedures, training, etc. that you'll need to be putting in place.
Thank you. And another one for you, Helen, before you disappear. Who will be able to file documents at Companies House when the reforms changing this come in?
I think I'm having the same issue as you with my camera. But yeah, so generally speaking, any individual delivering documents to Companies House on their own behalf or on behalf of other individuals will need to have their identity verified with Companies House before they can deliver the documents. And if you're delivering documents to Companies House on behalf of another person, you'll need to be an officer or employee of the company on whose behalf the document is delivered and have your identity verified. Or you will need to be an authorised corporate service provider or an officer or employee of an authorised corporate service provider. The ACSP regime is intended to be for intermediaries such as accountants, legal advisors, company formation agents, etc., who are registered with a supervisory body for anti-money laundering purposes. and therefore already have an existing obligation to carry out customer due diligence checks on their clients. So any individual or entity who wishes to become an authorised corporate service provider will need to register with the registrar and demonstrate that they are supervised for anti-money laundering purposes. So that's kind of it in a nutshell. But obviously there's kind of additional detail around that, but I won't go into it right now.
Thank you. I think we've got another question. Liv, this is probably for you. And I think a client's asked me this actually, will identity verification apply to non-executive directors?
Thanks, Kirsty. Yes, so identity verification is going to apply to all statutory directors. So that's executive and non-executive directors, all directors that are registered at Companies House. So yeah, they're going to be required to verify their identity, which is why we've been saying to clients especially, like, you know, make sure if you've got full board of directors and that you start briefing them so they know that they're going to have a photo ID, which most people do have these days, but they can get, you know, spread awareness now so that when it does come into force, people are ready with their ID to go through the process.
Thank you. Otherwise, in terms of the amount of penalties, Cameron, in what scenarios will companies seek to impose civil penalties, so a fine of up to £10,000?
Yeah, thanks, Kirsty. So it's our understanding that further guidance is to come in the form of further regulations on this point. However, at this stage, we understand that in order to exercise the new power to impose a civil penalty, such as a fine of up to 10,000, Companies House will need to be satisfied beyond reasonable doubt that an offence has been committed. But as I say, further guidance is expected on this point, so I'll be maintaining a watching brief, as it were.
Thanks, Cam. I think there might be another question or two, but we'll pick those up separately and email the answers through. And obviously, if you'd like to know more about ECCTA as and when the legislation fully comes into force, please let us know. And thank you all for attending. Enjoy the rest of your day and the football match on the weekend if you're interested in that. Take care now. Bye.